I want to start with something I think we all know, but always don't say plainly. The Indus Waters Treaty is one of the genuine success stories of international diplomacy. It was built to do something extraordinarily hard: give two countries that have fought multiple wars a legal and technical framework for sharing something they both need to survive. And for over 60 years, it worked. What I've been asked to look at this afternoon is the broader picture: how river treaties around the world are designed to prevent conflict, what makes their institutions strong or fragile, and what the global framework of water law has to say about where we are right now. And I think when you look at the comparative record, the Danube, the Mekong, the Nile, the picture is actually clarifying, not discouraging, because it tells us very precisely what works, what's at risk, and what needs to be protected. The International Commission for the Protection of the Danube River, the ICPDR, spans 15 parties, including countries that were on opposite sides of the Cold War. Its legal foundation in the 1994 Danube River Protection Convention. And here's the telling detail. That convention includes a small dispute settlement mechanism. It has never once had to be used. Not because there are no tensions, there are, but because the technical working groups meet regularly, they share data, and resolve differences before they become political crises. That is exactly what institutional conflict prevention looks like when it's working. The Mekong tells a more cautionary story. Scholars studying that basin have found explicitly that withholding hydrological data can itself incite regional conflict, that controlling data becomes a political weapon. The Mekong River Commission established a formal data sharing procedures back in 2001, but implementation remained weak for years. It wasn't until 2020 that an agreement was reached with China to share river level data twice daily and year-round. The lesson is direct. When the flow of information stops, trust erodes, and the space for miscalculation grows. Pakistan has written to India 3 times, twice in 2025 and again in May of 2026, about abnormal and abrupt flow variations on the Chenab. That is not a procedural complaint. That is a downstream country losing visibility into what is happening upstream. The Mekong experience tells us exactly how dangerous that is. The Nile Basin Cooperative Framework Agreement, which finally entered into force in 2024, drew almost word for word on the 1997 UN Watercourses Convention, codifying the principle of equitable and reasonable use, the obligation not to cause significant harm, and mandatory data exchange. The Nile case shows us something important. Even when bilateral arrangements fracture, customary international law remains as the underlying framework. States cannot simply exit their obligations by declaring a treaty suspended. The law does not work that way. The 1997 UN Watercourses Convention is the authoritative global framework on shared rivers. Its core principles: equitable use, no significant harm, prior notification before major upstream actions, and regular data exchange. These are not just treaty obligations for the countries that signed it. They reflect customary international law, which is binding on all states regardless of signature. The International Court of Justice confirmed this in the Gabček-Kavel Naj Maroš case, a dispute fittingly over suspended treaty on the Danube. The court held that customary one-party claims a treaty has been suspended. You cannot unilaterally walk away from the legal framework simply by announcing that you have. The Permanent Court of Arbitration, the PCA, made that directly relevant to the Indus Basin. In its June 2025 supplemental award, the court found that India's declaration of abeyance does not end the tribunal's jurisdiction. The treaty's dispute resolution architecture, the very machinery built to prevent escalation, continues to function. And in May of 2026, the court issued an award on the question of maximum pondage that substantively affirmed limits on upstream water control. India has rejected both. But rejection is not the same as nullification. An arbitral award does not disappear when a party calls it illegal. Paktan Sun Serwanda treaties must be performed in good faith. You heard another speaker say that earlier today. This is not a polite aspiration. It is the foundation on which the entire system of international agreements rests. When it is eroded in one place, the consequences reach far beyond that basin. Against that comparative backdrop, I want to say something clearly. The Permanent Indus Commission is, by any global standard, a remarkable institution. Senior engineers with diplomatic standing, a mandatory meeting schedule, inspection rights, a tiered dispute ladder, commission to neutral expert to court arbitration that is specifically designed to catch problems at the lowest possible levels before they climb. The academic literature on the Commission notes that it resolved the vast majority of questions brought to it across 6 decades, through 3 wars, military standoffs, and sustained political tension. No other bilateral water commission has been stress-tested that way and survived. That is an institution worth protecting. But here's what the Danube, Mekong, and Nile all show us consistently. Commissions prevent conflict, not primarily by resolving legal disputes. They prevent conflict by maintaining contact. Regular meetings build familiarity. Joint inspections create shared technical understanding. Data exchange removes the information gaps that feed political suspicion. When that contact is severed, when inspections are refused, when data goes dark, when commission meetings lapse, the buffer disappears, and the downstream consequences, in the most literal sense, fall on Pakistan. The seminar documentation for today identifies exactly that pattern on the Indus. Reduced cooperation on inspections, incomplete data exchange, erosion of regular commission engagement. I want to be direct about what the comparative record says. That sequence is not a diplomatic inconvenience. It is the early warning signal that the institutional safeguards are in fact failing. Based on what the comparative record shows, I'd like to offer 4 things that the international community and this convention should be pressing for. Restore commission engagement unconditionally. The Permanent Indus Commission must meet. Its mandate is not contingent on the state of political relations. That is the entire point and reason for building a technical institution. The meeting schedule is a legal obligation, not a diplomatic favor. Mandate real time for data showing all flow variations. Pakistan's documented concerns about the Chenab are precisely the kind of issue the Commission exists to address. The data must flow, and it must flow in both directions, transparently. Respect the arbitral process. The Court of Arbitration has jurisdiction. Its awards are valid. A state that disagrees with a tribunal's competence has legal avenues to contest that. But non-participation and rejection do not make the awards just disappear. The international community should say so clearly. Affirm that abeyance has no basis in international water law, the 1997 Watercourses Convention, the ICJ, and the PCA have all pointed in exactly the same direction. Unilateral suspension of a treaty's obligations is not a recognized legal act under the framework governed by shared watercourses. I want to close with this. The Indus Waters Treaty matters beyond the Indus Basin. It is one of the clearest demonstrations in history that international institutions can manage water conflict even between adversaries. That proof of concept matters to every shared river basin in the world, and there are 310 of them. What is happening right now is not just a bilateral dispute. It is a test of whether treaty-based cooperation can be abandoned unilaterally when it becomes politically inconvenient, and whether the international community will say anything about it. The institutions that were built to keep the water from becoming a cause of war must be allowed to function. For 240 million people whose lives depend on the Indus, there is no alternative. Thank you.
इस्लामाबाद से इंतास माहिदा बैनुल-अक़वामी सेमिनार से मुनसिफाना आलमी पॉलिसी की माहिर लॉरी ए वॉटकिंस का खिताब जारी था। उनका कहना था ये माहिदा के इंतहाई मुश्किल मकसद के लिए तश्कील दिया गया था। इंतास माहिदा बैनुल-अक़वामी सफारतकारी की हकीकी कामयाबियों में से एक है। उनका कहना था अपनी गुफ्तगू का आगाज़ एक ऐसी हकीकत से करना चाहती हूँ जिससे हम सब वाकिफ़ हैं। अहम मौजू पर इज़हार ख़याल करना मेरे लिए बाइस मुसरत है। किसी भी बैनुल-अक़वामी आबी मुआहिदे की असल ताकत राबतों के तसलसल में मुज़म्मिर होती है। जब आबी मालूमात का तबादला रुक जाए तो बदएतमादी, गलत अंदाजे और बिलाखिर कशीदगी जन्म लेती है। उनका कहना था मुआहिदे के तहत मुश्तरका मुआयने और तनाज़ात के हल एक मरहलावार निज़ाम मुकर्रर किया गया है। मुस्तकिल इंडस कमीशन आलमी मयार के मुताबिक एक गैर मामूली और काबिल कदर इदारा है।
Acceding to the UN Water Course Convention of 1997.